Picture this: a man named in countless family stories as careful, organized, the one who always had his affairs in order, passes away at 78. His children gather in his living room a few weeks later, and someone finally finds the will in a drawer in his home office. It's 11 years old. It names a guardian for his children, who are now adults with children of their own. It leaves a savings account to a bank that closed down years ago, and it says nothing at all, about the house he bought 6 years after he signed that will, or the retirement account he rolled over twice since then. His family assumed that having a will meant having a plan. What they didn't know is that a will is only as good as what it actually covers, and how current it is, and whether it even controls the asset in question at all. That gap between what people assume a will does and what a will actually does is where so many families end up confused, frustrated, and sometimes in court, at the exact moment they can least afford to be. Here's the truth that doesn't get said out loud very often. A will is one of the most misunderstood documents in personal finance. People treat it like a magic shield that protects everything they own and guarantees their wishes will be followed exactly. But a will has limits. It doesn't avoid probate. It doesn't control certain assets no matter what it says, and it can be undone by something as simple as forgetting to update a beneficiary form. If you've ever assumed that signing a will means you're done with your estate planning, this video is going to challenge that assumption gently, but directly, because your family's peace of mind might depend on it. Now, before we go any further, let's be clear about what this video is and isn't. I'm not an attorney, I'm not a financial advisor, I don't have a law degree, and I'm not licensed to give you legal advice about your specific situation. What I am is someone who has spent a lot of time researching how estate planning actually works in the real world, talking with people who've gone through it, and trying to translate the legal jargon into plain English so families can understand the basics before they ever walk into an attorney's office. Everything you hear in this video is general education. It's the kind of foundational understanding that helps you ask better questions and avoid the most common pitfalls. But estate law varies significantly from state to state. What's true in California can be completely different in Texas, or Florida, or New York. So nothing here should replace a conversation with a licensed estate planning attorney who knows the rules where you live. Why does this matter right now, today, as you're watching this? Because most people don't think about their will until they're forced to. A health scare, the birth of a grandchild, the death of a parent that suddenly makes mortality feel real. And in that moment of motivation, they often make a will, feel a sense of relief, and then never think about it again for a decade or more. Life changes, laws change, assets change, and the will sitting in that drawer slowly becomes a document that no longer reflects reality. That mismatch is exactly where families end up blindsided. By the end of this video, you're going to understand exactly what a will can and cannot do, why probate happens even when there's a perfectly valid will, the handful of mistakes that quietly undo people's intentions, and the practical steps you can take to make sure your wishes actually hold up when it matters most. If any of this feels useful to you, consider subscribing because we cover these topics: wills, trusts, probate, and the real-life situations families face every single week, and this channel exists to help you walk into these conversations with confidence instead of confusion. Let's start with the foundation, what a will actually is and what it actually does. At its core, a will, sometimes called a last will and testament, is a legal document that states your wishes for what happens to your property after you die, and who you want to be in charge of carrying that out. That person is called your executor, sometimes called a personal representative, depending on your state. Your will can also name a guardian for minor children, which is one of its most important functions for younger parents. It can specify who gets what, this piece of jewelry to this grandchild, this car to that nephew, the remainder split among your children in whatever proportions you choose. But here's the part that surprises people. A will does not automatically transfer property the moment you die. A will is essentially a set of instructions that gets handed to a probate court. Probate is the legal process where a court officially validates the will, appoints the executor, and supervises the distribution of assets according to the will's terms, or according to state law if there's no will at all. That word, supervises, is important. Even with a will, your estate generally still has to go through this court process in most cases, unless your assets are specifically structured to avoid it. That single fact surprises an enormous number of people because they assume, I have a will, means my family skips all that court stuff. In reality, having a will usually just means the court process is more predictable and contested, rather than non-existent. There's another critical limitation that catches families off guard constantly. A will does not control everything you own. Certain assets pass outside of your will entirely, based on how they're titled or who you've named as a beneficiary. Life insurance policies go to whoever is named as the beneficiary on the policy itself, regardless of what your will says. Retirement accounts like 401ks and IRAs go to the named beneficiary on file with the account custodian. Bank accounts with a payable on death designation or property held in what's called joint tenancy with right of survivorship also bypass the will and transfer automatically to the surviving co-owner. This means your will could say one thing and your actual beneficiary designation could say something completely different, and the beneficiary designation almost always wins. People update their will after a divorce and feel like they've handled it, only to forget that their ex-spouse is still listed as the beneficiary on a life insurance policy from 15 years earlier. The will doesn't override that. It's a gap that has quietly created family heartbreak more times than anyone can count. A will also generally has no power over assets held inside a properly funded revocable living trust, which we'll talk about more in a moment, because those assets are technically owned by the trust, not by you personally, and trusts operate under their own separate set of instructions. So what does this all mean in plain terms? A will is essential. Almost everyone should have one. It's the backbone of a basic estate plan, and dying without one, what's called dying intestate, means a state's default formula decides who gets your property, which may have nothing to do with what you actually wanted. But a will is not a complete solution on its own. It's one tool in a toolbox, and understanding its limits is just as important as understanding its purpose. Let me walk you through a situation that illustrates exactly how this plays out. Imagine a woman, we'll call this a hypothetical situation rather than a real case, who creates a will in her early 50s, shortly after her father passed away, and the experience scared her into taking action. In her will, she leaves her entire estate equally to her 2 adult children. Smart move, responsible, exactly what an attorney would recommend at that stage of life. But over the following 15 years, her life changes in ways the will never gets updated to reflect. She remarries, she opens a new investment account, and names her new spouse as the sole beneficiary, because that's just what the paperwork asked for at the time, without much thought. She also buys a vacation property and titles it jointly with her spouse, which means it will automatically transfer to him, not through the will, the moment she passes. When she eventually dies, her children discover that her will, still saying everything split equally between my 2 children, actually controls only a fraction of her estate. The investment account, often one of the largest assets, goes entirely to her surviving spouse because of the beneficiary designation. The vacation property goes to him too, automatically, because of how it was titled. The children are left wondering why their inheritance is so much smaller than they expected, and worse, they're left wondering if their mother changed her mind about them, when in reality, she simply never went back and aligned her other paperwork with her will. This is the quiet tragedy of outdated or incomplete planning. It's not usually malice, or even a change of heart. It's neglect of the small administrative details that turn out to matter enormously. And it's a situation that's entirely avoidable with periodic review, which is exactly why we're walking through all of this today. Now let's talk about probate itself, because this is where a lot of fear and confusion lives. Probate is not inherently evil, despite how often it gets villainized online. It exists to make sure debts get paid, taxes get settled, and assets get transferred to the right people under court supervision, with a paper trail that protects everyone involved, including the executor. But probate has real downsides that explain why so many people try to avoid it. First, it's public. Once a will enters probate, it generally becomes a matter of public record, meaning anyone, a nosy neighbour, a distant relative, a stranger doing research, can potentially go to the courthouse or look online and see what you owned and who you left it to. Second, it takes time. Depending on the state and the complexity of the estate, probate can take anywhere from a few months to well over a year, sometimes several years if there's a dispute. During that time, assets are often somewhat frozen, which can create real financial strain for a surviving spouse or family members who are depending on access to those funds. Third, it costs money. Court filing fees, executor fees, attorney fees. These typically come out of the estate before anyone receives their inheritance, and depending on the state and the size of the estate, that can add up to a meaningful percentage of the total value. This is exactly why so many people pursue strategies to minimize what passes through probate, even while still having a will as a backstop. The most common tool for this is a revocable living trust. Here's the plain English version of how it works. You create a trust document, and then you fund the trust by retitling your assets, your house, your bank accounts, your investment accounts, so that they're owned by the trust instead of owned by you personally. You're still in control during your lifetime. You can typically act as your own trustee and use the assets exactly as you did before. But because the trust technically owns the property, rather than you as an individual, those assets generally don't have to go through probate when you pass away. Instead, a successor trustee you've named simply steps in and distributes the assets according to the trust's instructions, often in a matter of weeks rather than months or years, and without the public court process. It's important to understand that a trust isn't automatically better than a will for everyone, and it isn't free. There are setup costs, and more importantly, there's the ongoing responsibility of actually funding it correctly. This is one of the most common and most expensive mistakes people make. They pay an attorney to draft a beautiful trust document, and then they never actually transfer their house, their bank accounts, or their other assets into the trust's name. An unfunded trust is sometimes jokingly called an empty box in estate planning circles, because the document exists, but it doesn't control anything, since nothing was ever legally moved into it. Their family ends up in probate anyway, despite having paid for a trust specifically to avoid that outcome, simply because the funding step, the part that requires going to the bank, calling the title company, updating deeds, never got finished. This is precisely the kind of detail a licensed attorney in your state can walk you through and help you execute correctly, because the rules for properly titling different asset types vary significantly depending on where you live and what you own. Let's also talk about something people rarely consider until they're forced to: the role and burden of the executor. Naming an executor in your will isn't just a formality. You are choosing the person who will manage potentially dozens of administrative tasks during one of the most emotionally difficult periods of their life. That includes notifying financial institutions, filing the will with the probate court, inventorying assets, paying off debts and final expenses, filing final tax returns, and eventually distributing what remains to beneficiaries. It is, frankly, a part-time job layered on top of grief. People often name their oldest child, or whoever seems most responsible, without ever having a real conversation about whether that person wants the role, lives nearby, or has the bandwidth and temperament to handle conflict among siblings if disagreements arise. Naming a co-executor, or at least discussing the role honestly with the person you're choosing before you finalize anything, can prevent enormous strain later. Some families even consider naming a neutral third party, like a trust company or an attorney, specifically to keep the peace among siblings who might otherwise clash over decisions during an already painful time. There's another layer worth understanding: the difference between a will and what's sometimes called an advance directive or power of attorney, because these get confused constantly. A will only takes effect after you die. It has zero power while you're alive, even if you're incapacitated. That's a separate set of documents entirely: a durable power of attorney for finances, and a healthcare power of attorney or advance directive for medical decisions that allow someone you trust to step in and make decisions on your behalf if you become unable to make them yourself due to illness, injury, or cognitive decline. Without those documents in place, even a spouse or adult child may need to petition a court for guardianship or conservatorship just to pay your bills or make medical decisions while you're still alive but incapacitated, a process that is often more expensive, more stressful, and more public than most people ever imagine. A complete estate plan generally addresses both halves of this picture: what happens if you become incapacitated while alive, and what happens after you die. A will only ever covers the second half. Now let's address some of the most common myths and mistakes that show up again and again, because clearing these up might be the most valuable few minutes of this entire video. Myth number 1. I don't have enough money to need a will. Estate planning isn't only for the wealthy. If you have a home, a car, a bank account, or minor children, you have things worth protecting and decisions worth controlling. And dying without a will means a court formula decides for you, not your wishes. Myth number 2. My will covers everything I own. As we've covered, beneficiary designations and jointly titled property typically override the will entirely, so your will might control far less than you think. Myth number 3. A handwritten will I found online is just as good as one drafted properly. Some states do recognize certain handwritten or holographic wills under specific conditions, but the requirements are strict and vary enormously by state, and DIY documents are notoriously prone to technical errors that can render them invalid or trigger exactly the kind of court dispute you were trying to avoid in the first place. Myth number 4. Once I sign my will, I'm done forever. A will isn't a one-time event. It's a living document that should be revisited after major life events: marriage, divorce, the birth of a child or grandchild, the death of a named beneficiary or executor, a significant change in assets, or a move to a different state, since state laws genuinely differ on what's required for a valid will. Myth number 5. Probate is always a disaster, so I just need to avoid it at all costs. Probate has real downsides, but it isn't inherently catastrophic, and for smaller or simpler estates in some states, it may be straightforward, fast, and not worth restructuring your entire financial life to avoid. The right approach genuinely depends on your specific assets, your state, and your family situation, which is exactly the kind of judgment call a licensed attorney is trained to help you make. So what should you actually do with all of this information? Let's walk through it as a practical pros checklist you can start working on this week. First, locate your current will, if you have one, and actually read it again, even if it's been years. You might be surprised what it says, or doesn't say. Second, make a simple list of your major assets: your home, retirement accounts, life insurance, bank accounts, investment accounts, and next to each one, write down how it's titled and who the named beneficiary is, if any. This single exercise reveals more gaps than almost anything else you can do. Third, compare that list against your will and ask yourself honestly whether they tell the same story, or whether there are contradictions, like an ex-spouse still listed somewhere they shouldn't be. Fourth, think honestly about your executor choice. Is this still the right person, given where everyone lives now and how your family dynamics have evolved? Fifth, if you don't have a power of attorney or healthcare directive yet, recognize that this is a separate and equally urgent piece of the puzzle, not something your will already handles. Sixth, write down any major life changes since your will was last signed: a marriage, a move, a new grandchild, a business you started, because each of these is a natural trigger point for a review. And finally, take this list, along with your questions, to a licensed estate planning attorney in your state. You don't need to have all the answers before that meeting. You just need to walk in informed enough to ask sharp questions and understand the answers you get back. I want to leave you with something a little more personal than a checklist, though. Estate planning isn't really about death, even though it's triggered by thinking about death. It's about love, made practical. It's the difference between leaving your family with clear answers during an already devastating time, or leaving them with confusion, paperwork chaos, and sometimes even conflict with each other, layered on top of their grief. Nobody plans their estate because they enjoy thinking about their own mortality. They do it because they love the people who'll be left behind, and they want to make an unbearably hard moment just a little bit easier for them. A will that's current, paired with beneficiary designations that actually match your intentions, and a clear understanding of whether a trust makes sense for your situation, is one of the most quietly generous gifts you can give the people you love. It says, without ever having to say it out loud, "I thought about you, I planned for you, I made this easier, even though I won't be here to see it." So here's what I'd encourage you to do after watching this video. Don't let this become another piece of information you absorb and then forget by tomorrow. Pull out your will this week, even if it feels uncomfortable, even if it's been sitting untouched for a decade. Look at it with fresh eyes. Make that list of your assets and beneficiaries we talked about. And then schedule time with a licensed estate planning attorney in your state, because the laws governing wills, trusts, and probate are different from state to state. And even some of what felt clear-cut in this video could play out differently depending on exactly where you live and what you own. Everything in this video is general education, not legal advice. It's meant to help you understand the landscape so you can walk into that attorney's office prepared, informed, and ready to build a plan that actually reflects your wishes and protects your family. Before you make any decisions about your will, your trust, or your estate, please talk to a licensed estate planning attorney where you live. If this video helped you see your own situation a little more clearly, consider subscribing, because we're here every week helping families like yours navigate exactly these conversations with a little more confidence and a lot less fear.